Welcome to the podcast for the Tuesday morning Q&A with Boyd W. Shepard D.D.S. J.D. Each Tuesday morning Q&A podcast is an edited and shortened version of the previously held live Q&A Zoom session. On Tuesday mornings each week, join attorney Boyd Shepard for a 1-hour Q&A call where you can ask Boyd questions. Then hear his detailed and knowledgeable responses to the legal concerns and business experiences of other dentists. For more information on how you can join in on the Q&A each Tuesday at 7:00 a.m., please go to legaldental.com.
Good morning. Happy Tuesday. Good to see everyone. At least see you online. Thanks for being here. Hope your week's off to a great start as usual. And here we are on January the 24th at 7 a.m. So can't thank you enough for joining in and participating. We will get into the question here shortly as folks join in. I want to remind everyone as we go along here, each week I am here to answer your questions. I want to be available to you. If you've had any questions come up during the week that are legal questions that would be good for me to answer, I'm happy to do that. So please ask questions. You can type your questions in the chat. Just type away, as many folks often do as we go along. Your other option, of course, is just to unmute yourself and ask away. Feel free to do that. I'm happy to be interrupted even while I'm speaking to address any questions or concerns. As we go along, I typically get rolling, and I do have my question that I emailed about yesterday that I'll get into here shortly. And if anything comes up about that particular subject that reminds you of anything, please let me know. If there's anything that is new and different and completely a different subject, that's fine too. If I am not able to answer your questions, I will definitely let you know and hopefully guide you to the place where you might be able to get the answer. I'm not afraid to admit when something is outside of my experience or knowledge. Many times if that happens, what I do is say, I will get back to you. I will research that and make a note of it and bring it up next week. So it's all good. The other option, of course, is to email me your questions in advance for the next week. And seems like since we started the Q&A in May of last year, in the beginning, many would do that. They would send me their questions via email ahead of time. And I don't get that as much anymore, and that's okay. I think it's just cyclical. It's just coincidental. It's if folks have a question and they remember, they send it to me. But, make a note on your desk, post a note, just a reminder to yourself. Send Boyd a question if anything comes up. I'm happy to answer it for you, particularly if it's fitting for the Q&A and something that everyone can learn from. And oftentimes, there's no doubt about it, every time I would say, I am learning right alongside everyone else. That's why your questions are so important. We're all learning. I'll mention it at the end, but of course, from the learning perspective, there is CE available. I typically give up to at least a half an hour, 0.5 hours of CE and risk management for the Q&A sessions, because we do get into board questions, whether it's the question of the day or not. Inevitably, we do cover risk management issues as part of the Q&A. So if you attend and you want to receive a certificate of completion for at least a half an hour for each, sometimes folks will send me, Boyd, I attended on these 3 dates, and I will send them a certificate that's signed off that says 1.5 hours as an example. So You can keep track and let me know later, or you can do it on a daily, every Tuesday basis. It's not unusual for me to get emails right after the Q&A, and they say, "Good morning, Boyd. Thank you for today's Q&A. I attended. Please send me the certificate." And I do my best. It's unusual for me to not turn that around right away. And if I don't, I definitely turn it around within 24 hours. The only reason I wouldn't turn it around right away is if I had to leave my office right after the Q&A, but I'm happy to do that. And at the end, I'll show you what that certificate looks like. But as many, if not all of you know, I am an approved CE provider, recognized provider by the state board, particularly in the risk management area. I'm listed on their website under Rule 104.2 for CE. And so it's completely legit. You don't have to worry about that. And I'm happy to do it because you've attended and we've had this time together, and it's definitely, hopefully, education. So y'all educate me, hopefully I educate you. So we've had a lot of folks on this morning. Thank you again for joining. We're about to get right into the question, and we'll do that now. But I do want to remind everybody one more time, as it says right there, please ask questions. That's what we're here for. It's the Tuesday morning Q&A. So if you'll give me your questions, hopefully I can give you some answers. So keep that in mind as we go along. So we'll get into the question of the day. So I sent this via email yesterday, and the email, or the question rather, says your associate or another member of your office team has violated a board rule, and this has resulted in a complaint against your license and an investigation of your office. How is that legally possible? Now, this assumes, of course, the question assumes that you are a practice owner and that you have associates, right? So that may not be everyone in the group. It may be that you are not yet an owner of a practice, but you may own a practice in the future. It may be that you're an associate now, and this is a good rule to be aware of. The rule we're about to discuss from the standpoint that a great associate is a team player and does not want to cause any problems for their employer, obviously. This question assumes, like I said, that you're a practice owner, that you have an associate, and it's that dynamic that the question is basically saying, how can the practice owner, who must be a licensee, be in trouble with the state board when the associate was the one that allegedly violated the board rules? Why isn't the associate suffering a complaint or being investigated? And it may very well be that the associate is also subject to the investigation and the complaint. That's possible. The case that this question stems from that reminded me of this particular issue, in that case, I don't believe the associates were investigated at all. And that's what really made it interesting, was that I was representing the practice owner, and the practice owner was being held responsible for violations that were created or caused by, at its base, the associates. Part of the problem, I believe, in that particular case was that the associates no longer worked at that practice. This particular client had multiple issues. So what I'm going to do is, you see the question, I'm going to get into the board rule and get everybody oriented on what we're dealing with here. So again, the question is, how is it legally possible that your office, that you as the practice owner, are being investigated if it was the associate or another team member that violated the board rule? How is it that you as the practice owner are also suffering the complaint and investigation when you weren't part of that treatment? So as everybody knows, first place you start is on the state board website, going to the board rules. And once you're there, the rule that you're looking for on this is Rule 108.1, professional responsibility. And hopefully everybody can see that well on their screen. But basically, we're talking about it's the professional responsibility rule, which is one of those rules that really captures a lot of different ways to violate the rules. And it's all based in this concept of professional responsibility. It is the first rule in Chapter 108, Professional Conduct, Professional Responsibility, and that's the title of this rule as well. So it says a licensed dentist shall conduct his or her practice on the highest plane of honesty, integrity, and fair dealing. So there's your fair dealing language right there. We'll get to that in a moment. In order to safeguard the dental health and welfare of the public and the dentist-patient relationship and fix professional responsibility for dental services, no dentist or any other licensee or certificate holder of the board shall, one, circumvent or attempt to circumvent any provision of the Dental Practice Act or any rule or the order of the board. Two, participate directly or indirectly in any plan, scheme, arrangement, attempting or having its purpose or result the evasion of any provision of the Texas Dental Practice Act or any rule of the board. And the one that we're drilling down to and drilling down on today is number 3. Fail to exercise reasonable diligence to prevent partners, associates, and employees from engaging in conduct which would violate any provisions of the Texas Dental Practice Act or any rule regulation of the board. So as you read that, you see the synthesis or derivation of the rule where it starts with no licensee shall circumvent the rules. Number 2, participate in the circumvention of the rules or evasion of the rules. Or 3, fail to exercise reasonable diligence to prevent partners, associates, and employees from engaging in conduct. And by the time you get to number 3, it's like, wow, here I am, a practice owner, and I'm already on the hook as a licensee. But not only do I need to be responsible for myself, but I have to make sure that I exercise reasonable diligence to make sure my partners, associates, and employees are not engaging in conduct which would violate any rules of the Dental Practice Act. And this opens up a huge level, it's a whole other level of responsibility as a practice owner when you have associates, when it comes to this idea of professional responsibility under Rule 108.1. Now, I would encourage everyone to, I'll leave it up there for a moment, to scan the remainder of Rule 108.1 and get a feel for it. And I would also recommend that everyone make a note right now to go back and look at this rule in detail and understand how broad it is and how much it captures in the way of fair dealing and professional responsibility. But we're focusing today on subpart 3 of Rule 108.1, the failure to exercise reasonable diligence to prevent partners, associates, and employees from engaging in conduct which would violate any provisions of the Texas Dental Practice Act or any rule, regulation, or order of the board. Hello, everyone. A quick break here in the middle. This is Boyd Shepard. I wanted to make sure that you know, if you are listening to this podcast, you can receive up to 8 hours of continuing education credit in risk management that satisfies the Texas State Board of Dental Examiners 8-hour biennial requirement. To receive this continuing education credit in risk management, please consider subscribing to the podcast for the Tuesday morning Q&A. Go to my website, legaldental.com, for more information. Thank you for listening. And the case that this comes from, or the case that this particular rule was alleged in, was this case. And let me just say real quick, in this particular case, this was actually, and this was back in 2015, but you'll see as it's described, this case was resolved in 2015, maybe early 16. This is still the rule. The rule has been around since like 2001 in its current form, and it hasn't changed since then, number one. Number two, this was the first time, I mean, I'd already been practicing law since like 94, 95, working on board cases. This was the first time that I had seen this particular rule alleged this way, to capture or to grab the practice owner and make them responsible and liable for the conduct of their associate or employee. So the way that this rule manifested itself in the wild, as they say, resulted in this particular allegation. So I've brought these up before. This is a screenshot of a board order where number 5 and 6 at the top are the continuation of several. You can see that there were actually 6 findings of fact against this particular licensee, this licensed dentist who was suffering a board case. And so they had 6 findings of fact. I just grabbed number 5 there is the one we're talking about. During the time period from July 2012 through November 2012, respondent, the owner of the practice, failed in his duty of fair dealing. And you remember that language from Rule 108.1, subpart 3. During the dental treatment of patient 3, specifically, respondent failed to use reasonable diligence to prevent associates or employees from failing to treat patient 3's orthodontic condition and failing to properly dismiss patient 3 pursuant to 108.5. And we know 108.5 is titled patient abandonment, and it's the rule that outlines the process that allows you to legally dismiss a patient. So what was interesting about this to me was that the board found a way to stretch Rule 108.3 to make the practice owner responsible for the conduct of the associates for failing to treat patient number 3's orthodontic condition and failing to properly dismiss the patient pursuant to Rule 108.5. And in your mind, the first thing my client at the time was saying, well, what about the associate? And the answer is, well, yeah, the associate, that the former employee or the current employee, whichever the case may very well be subject to an investigation and a complaint as well. But just because they're subject to the same thing, they may be facing a board order, an investigation, findings of fact that say that they individually failed to treat patient 3's orthodontic condition and failed to properly dismiss the patient. But the board is saying under Rule 108.1, subpart 3, that you as the practice owner failed in your duty of fair dealing to use reasonable diligence to prevent these associates and employees from doing those things. They're capturing everybody under this rule. So it's an opportunity for awareness of just how broad, I guess, that the board rules are, and the level of responsibility that you have as a practice owner, that you're obviously the responsibility and the huge amount of liability and the work that you do as an owner when you, I mean, just getting into healthcare, getting into dentistry, period. It is a life's journey where you've been given a gift, you've been given education, you've been given the opportunity, you've been given talent. Everything about your life is about taking care of others. And so you pursue this great cause, and yet there's the legal side of things that says, in the best interest of the patient, not only are we going to hold individual licensees responsible, the state board, but the state board is going to hold responsible at a higher level you for, as a practice owner, for anything that may happen by virtue of not using reasonable diligence to make sure that your associates are taking care of their business. Now, the obvious question, at least for me, is, well, what is this reasonable diligence? What is it that a practice owner has to do to demonstrate reasonable diligence? Does an employment agreement that you have with your employee, where you list out the responsibility and liabilities of the owner versus the employee, is that a defense? Does that excuse you under the board rules from saying, hey, I laid out all of the responsibilities, the employee failed to live up to those duties as outlined in the employment agreement? The employment agreement is my first example of me using reasonable diligence, because I put my employee and my associate on notice that this is what the expectation was. And that may be some level of defense where you demonstrate knowledge of the rule, you demonstrate that you as the practice owner have used reasonable diligence to do the best you can to hire the best associate or people who are going to act responsibly and treat patients responsibly and ethically and under the standard of care, and that may be it. But as in this particular case, as I recall it, it was a pattern over a long period of time where the doctor just could not demonstrate that they were involved in the participation of making sure, and that there was so much going on and so many problems with the record keeping, so many problems with the standard of care, that the board said, look, how can you have a practice where there's this many patients complaining and you're not aware of it, and yet your associates, it's like it's the Wild West at your office, and you're not taking care of business to either remedy the situation, to educate the doctors who work for you, or to dismiss them from the practice altogether. And in the meantime, patients are suffering. And that was their attitude, you know? So I just showed you a few allegations. It was a much more involved case that this is what it resulted in. So let me see about this question that's in the chat, and I appreciate it. If an associate leaves a practice and the contract states the owner will be responsible for retaining it and treating all patients formerly seen by the associate, does the associate need to notify all patients he is no longer the treating doctor and the owner is the doctor of record? So thank you for that question. That's a great question. So I always say that when you're coming up at the end of a business relationship between an associate and a practice owner, the employer, and it may be that you're at the end of the contract term, let's say it's a 1 year, 2 years, 3 years, whatever the agreement is, but you're at the end of that contract term naturally, according to the terms of the agreement, and the associate decides they want to move on. They give proper notice. There's no tension, there's no issues, there's no disputes, there's no problems. The associate's just ready to move on. And the owner of the practice is like, fine. But in the meantime, as pointed out in your question, there's patients that may be left in the middle of treatment. And so how do you handle that? And so there's really, first of all, the owner, employer, and the associate who's departing can certainly agree on, hey, there's X number of patients that are in the middle of treatment and I'm departing in 30, 60, 90 days. How are we going to handle these patients? You sit down and you talk about that and you work it out. The first place to me is, what is X? How many patients are we talking about? Is it 10? Is it 30? Is it somewhere in between? Is it more? Is it less? How many patients are in the middle of substantial treatment plans that they're either in temporaries or recent impressions? Something's at the lab, something needs to be seated, something needs to be delivered. Where are we on these patients? And you basically work out a spreadsheet on that. And if you approach it that way, you can then, it will reveal to yourself, well, this is the best plan of attack to or plan of action to take care of these patients over the period of time during the notice period, so that by the time of the last date of the term, you've gone from, let's say, 25 patients down to 5. And now you're saying, how are we going to take care of these last 5? You see what I'm saying? You work that out together. To answer your question, do you need to notify all of the patients that that you're moving on? And the answer is yes and no. In other words, will it be considered Rule 108.5 patient abandonment if you don't notify the patient? Possibly. And that's what you have to assess. What type of treatment are they in? And do they understand they have the opportunity to complete treatment in the office where they started the treatment? And should those patients be notified? And that is a case-by-case basis. I would lean towards, yes, they do need to be notified. And that's another reason to work it out between the associate and the employer before the associate moves on, because you don't want to be in violation of a non-solicitation or a non-compete just because you're trying to let the patient know under Rule 108.5, I'm moving on, but you can either let me finish the treatment and I'll come back to the office, or you can find me elsewhere and I'll take care of it there. Or the main thing the board's thinking about is, was the patient taken care of? And they don't really care about your contract. What they care about is the patient. And if you had an opportunity to notify the patient as well as work it out between yourselves ahead of time, that's the best course of action for everybody. Because when you take care of the patients and they'll appreciate it, it just reduces stress and problems for everyone. So I lean towards the answer to that question is yes, you do need to notify them. But what I've outlined is a way to approach it that you take care of each other on the business side, but the patient, who's the most important, is taken care of on the treatment side. We always have a great session. We always have a great time. We always have great questions by all of you. And so for those of you who are new today, this may have been your first time, please come back each Tuesday or as many Tuesdays as you can. We do have the blog and now the podcast available, so that if you missed one, you can go back and listen and catch it later. But we do appreciate, or I appreciate, everyone that shows up live. I really appreciate your questions, your comments. It means the world to me for you to participate. If there are additional questions during the week, any issues that come up, write it down. Send me a note, boyd@legaldental.com. Send me a note, Boyd, here's a question for next week. Feel free to do that, and I'll queue it up if I feel like it's appropriate and good for the Q&A. Like I said, we all learn from each other. So I hope everyone has an amazing day. Thank you for being here. See you next Tuesday. Have a great week and look forward to seeing all of you then. Thank you.
Thank you.
Thank you again for listening to the podcast for the Tuesday morning Q&A with attorney Boyd Shepard. For more information on how to join the weekly Q&A each Tuesday morning at 7 a.m., go to legaldental.com.
This voice was produced in Typecast, an artificial intelligence voice service.